Good morning and welcome to today's webinar. I'm Neil McLean. I'm a partner in the Government Regulation and Competition practice at Brodie's, and I play a leading role in our firm-wide education group. Working anti-clockwise, I'm joined by my partner, Joyce Cullen. Joyce is a partner in our litigation practice, and her clients include universities and independent schools. Joyce is also a governor at an independent school and will be offering that unique perspective as our final speaker. I'm also joined by Lynn Marr. Lynn is a partner in our employment law practice and she's very active in the education sector. She's also served in the past on the University Court of a Scottish university. And finally, I'm joined by Lynn Livesey. Lynn is a senior associate and specialist in health and safety law with a particular interest in acting for education clients. So that is who we are. Moving on to what we will cover today. So we have guests on the webinar from central government, local government, independent schools, colleges, universities. And we're also joined by guests from the private sector who work with those bodies. So the challenge that we've set ourselves is in 4 short presentations to touch on the legal issues created by the COVID-19 pandemic and the impact that has had across the education sector. Now, given the huge range of challenges the pandemic has presented, we won't be able to cover everything today. So if there is any issue we've not covered and you'd like to hear more about, then please get in touch and we can arrange a separate session to cover that. Our speakers will also aim to be clear when they're talking about something that has general application or where they're talking about something that is more specific to a particular part of the sector. And in terms of our running order, first I'm going to provide an overview of the legal framework and relevant guidance. We're then going to look at some employment law issues with Lynn Marr, moving on to some health and safety issues with Lynn Livesey, and finally Joyce is going to wrap up by looking at the education providers review, including some contractual and related issues. So moving on firstly to the legal framework. I'm afraid this is a seminar delivered by lawyers, so there has to be some law in it. And what I want to do is start with a reminder of the legal framework which has been constructed in response to the pandemic. And I want to do that for a couple of reasons. Firstly, to set the scene and lay the foundation for some of what my colleagues will say later on, but also because it's very important to understand the source of any power being exercised by government, so that you know the consequences in the event that there is a breach of the rules. And the consequences might be different depending on whether what has happened is a breach of the law or a breach of guidance. So we start with the Coronavirus Act 2020. It's an act of the UK Parliament, but most of the Scottish regulations have been made under it. It was followed by the Coronavirus Scotland No. 2 Act 2020, which complements and supports the Coronavirus Act 2020 and introduced various changes. Most notably for the purpose of today's seminar, the No. 2 Act contains provisions which enable a person with a student residential tenancy to terminate the accommodation agreement with their landlord, provided certain requirements are met. And it introduced a minimum notice period of 7 days, which was subject to various conditions, so a fairly significant change. We also have the local levels regulations, and those are the regulations which impose current restrictions on individuals, businesses and service providers, including the most recent level 4 restrictions, which we're all currently operating under. And they provide that by law, everyone must stay at home unless they have a reasonable excuse for leaving the house. And that's why we're delivering webinars in the way that we are at the moment. And finally, another piece of relevant law to this area is educational continuity directions, and they're made under the Coronavirus Act 2020, and they regulate how local authority education is to be run during the pandemic. So moving on to look firstly at where we are now in terms of schools. So restrictions on schools are imposed by way of educational continuity directions, and importantly, they only apply to local authority provision of education. The most recent of those directions was the No. 7 direction, which took effect on the 9th of January this year. And that provides that education authorities should close except for the provision of schooling and childcare to the children of key workers and vulnerable children. And I think that key worker status is probably what's proving most challenging for local authorities. And the definition of key worker was agreed with local authorities and is set out in guidance. But it's likely that there is some pressure being put on local authorities to make assessments about whether or not a person is a key worker so that their children can be accepted in schools. Education authorities are also allowed to remain open for the provision of remote learning and the preparation of remote classes, and also for the necessary use or maintenance of buildings. So the default position, as I'm sure many of you with children know and are experiencing already, is that education must be provided by way of remote learning, and schools are required to prepare for children to resume attendance at the earliest time it's safe to do so. The other thing just to note in relation to education authority provision is that certain legislative provisions have been disapplied, and an example of that is alterations made to the time limit in processes for placing requests. So moving on to further and higher education institutions. So unlike schools, further and higher education institutions are not explicitly told in legislation that they must close, and I should say the position is the same for independent schools. However, they must take measures which are reasonably practicable to minimise the risk and spread of coronavirus on their premises. Reasonably practicable is language used in health and safety legislation, and Lynn will talk about that later on. What the regulations provide is a non-exhaustive list of reasonably practical steps, and that includes things like provision of information and changes to layout of premises. The regulations also contain a legal duty, which is quite important, that institutions must have regard to guidance issued by the Scottish ministers. And the Scottish ministers have, as you would expect, produced a lot of guidance in this area. And the current guidance provides for staggered return periods for students, and otherwise that students should only attend institutions where their attendance is critical and time sensitive to their course or assessment and cannot be delivered remotely or postponed. Students are not to return to term time accommodation until face-to-face teaching resumes, and were they to do so without a reasonable excuse, they would be leaving the place where they are living for a non-essential purpose and therefore commit an offence. The regulations provide for various offences, and it's an offence to not take steps which ensure, as far as reasonably practicable, that 2 metres or 1 metre in certain spaces is kept between individuals. It's not an offence to breach the requirement to take all other measures reasonably practical, or to fail to have regard to the guidance issued by the ministers. But the reality is that compliance in the education sector is high, and the risk is very low that there would be any prosecution of education bodies for a breach of these regulations. However, being seen to fail to follow the regulations or the Scottish Government guidance carries significant reputational risk for organisations. It's therefore very important that education institutions and student accommodation providers understand what the current guidance says and how it impacts on their organisation. Before handing over to Lynn, I did want to say something about students. We could do a whole session of its own on students, and if there's any interest in that, then again, please get in touch with us direct. In its guidance for universities, colleges and student accommodation providers, the Scottish Government explained that institutions and providers are expected to have in place robust processes to ensure compliance with the COVID-19 rules and requirements. And by that, they mean dealing with it through existing misconduct policies, including making clear that a failure to adhere on or off campus could be treated as student misconduct. So it's important to take steps in order to comply with the guidance. And by doing that, you'll want to do things like understand the makeup of your student community in key risk areas. For example, do you have a lot of potentially returning international students or students returning from home? You'll need to keep under review existing policies and procedures, ensure those are adequate and can be used to take action where that's necessary. And as part of that exercise, you'll also want to consider how to manage a potentially large increase in student discipline cases for a failure to follow the rules. And that's all I wanted to say, really, by way of introduction on the legal framework. I'll now hand over to Lynn to go over the employment law issues.
Okay, thanks very much, Neil, and good morning to everybody. Yeah, I think it's fair to say that over the pandemic, employment lawyers have been extremely busy. There have been a wide range of employment issues impacting on employers, including obviously those operating in the education sector. And I think probably first and foremost, the most significant issue has obviously been the move to home working. So pretty much overnight, everybody at the start of the pandemic went home and we all embarked on this great working from home experiment, as it's often put. But as education authorities have moved towards online learning, working from home has obviously been set to continue, and it will continue. Schools are obviously still moving to online learning. A lot of universities have already said that they don't plan to have students back on campus until maybe September. So online working is obviously, or home working is set to continue. And what I think became immediately obvious to a lot of employers in the sector is that you've got to keep ensuring that you're complying with all of your employment law obligations to those employees, notwithstanding the fact that they're at home. And the most significant one of those has been the duties that you have to ensure that all your employees' health and safety is protected, and that is their physical well-being as well as their mental well-being. And that's quite a challenge when people are working remotely. And of course, there are a number of legal obligations at play here. There's a wide range of statutory obligations, starting really with the Health and Safety at Work Act and a whole range of associated regulations. I'm not going to talk about those because those sit much more squarely in the expertise of Lynn Lucy, who's going to speak a little bit later on. But I do think it's really important to remember that, leaving aside any of the statutory obligations and whether or not there are complaints to the Health and Safety Executive about a breach of those obligations or any enforcement action taken by them, employers have got to remember that they do have implied contractual duties. And so employers do have an implied obligation to make sure that they are taking all reasonably practical steps to ensure that employees have a safe working environment and that they have all the support that they need to be able to do their jobs. And where we're seeing this becoming a bit of a challenge across the sector is in an increase in the number of complaints from staff working at home remotely under quite pressurised conditions. And we are starting to see, unfortunately, come through quite a number of complex grievances, which, if they're not dealt with appropriately, again, challenging to do from remotely, they can turn into tribunal claims. So either constructive unfair dismissal complaints or discrimination complaints. I think it's this focus on health and safety really that has driven a lot of wellbeing initiatives across the sector. That has really come into sharp focus because people being at home do find it really difficult to stay connected with the workplace. And we are seeing, as employment lawyers, a really huge increase in the challenges of dealing with people who are suffering extreme poor mental health. So we are seeing a lot of initiatives to make sure, in all organisations, to make sure that they have measures in place to allow employees to stay connected to the workplace, education of employees on how to protect their own physical health and their own mental well-being, and trying to also train managers to be able to identify signs of mental ill health. As I said, there seems to be an unfortunate increase in extreme poor mental health, and that's also playing out in some of the statistics that we're seeing in relation to students, where there's been an increase in reports of student suicide as well. I've talked a little bit about online learning and working from home, but obviously there will be employees who are still coming onto campuses, and there are clearly health and safety obligations owed to those. So that might include staff that are teaching vulnerable children or adults, or children of key workers, or it just might include staff that have to be on campus to make sure that the estate is being maintained or getting ready to open the campus. And it's really important that, it sounds a bit obvious to say it, but in those circumstances, that that you are following the safer workplace guidance that's put in place for the sector, and that there's continual consultation and discussions about those with your health and safety committees and with the trade unions. And I mention that, albeit it's really obvious, because what we are beginning to see in employment law terms is an increase in claims under Section 44 and Section 100 of the Employment Rights Act. And these are little used provisions, but they essentially allow employees to make complaints of detriment or claims of automatic unfair dismissal if they are either dismissed or they're subjected to some sort of unfavourable treatment, like being put through an attendance management process, if they either don't do their duties or they don't come to work because they believe themselves to be at serious or imminent risk of danger in the workplace. And the key thing there is that risk is very broadly defined. So if somebody is having to come onto the workplace and they're concerned that they might be exposed to risk of infection from students or from other employees, they might just simply refuse to come into the workplace. And if there's negative consequences for them, then they might try and bring these sorts of claims. What is helpful in these circumstances, or to avoid these claims materialising or being successful if they do, is to basically communicate with your staff about the measures that you are taking to ensure that you're minimising the risk of transmission of virus or the dangers in the workplace from COVID, because their belief in these risks has to be reasonable. So the more that you are communicating with them about what you are doing, the less likely these claims are to actually arise. I'm going to mention overseas, people working overseas. This might happen more in the university sector, but what we started to probably find around May or June last year in discussions with clients was that they maybe had colleagues that didn't normally work overseas, but they found that they'd maybe gone to work at a home that they had abroad, and that is quite problematic. There's all sorts of complications that can arise from that. There are taxation issues, there are issues around whether there might be local employment laws abroad which are more favourable to employees that they might be able to take advantage of. There are issues around visas and immigration. They might need visas or permissions to work in the jurisdiction where they're working from home. There are insurance issues, data protection issues. And I've put up a link to a blog that one of my colleagues has written on this if you want to explore some of those issues in a little bit more detail. But I think suffice to say that it's useful to have a policy on this. So if you have employees whose role is in the UK, it's probably better to have them in the UK to do the job, or if not, then take some local advice from the jurisdictions that they are working in to make sure that you're not going to have any complex issues arising. I've mentioned furlough. I'm not really going to say anything about that because I think most people that have used the furlough scheme are now fully familiar with how to operate it and manage it. There are some ongoing issues, and if we move on to the next slide, and I might just look at some of the issues which we foresee coming up. You'll all be aware that obviously we're in this extended period of lockdown now, and you might be aware that at the beginning of January, the government guidance on the coronavirus job retention scheme was updated to put it beyond all doubt that those with childcare or caring responsibilities can ask to be furloughed. And so we anticipate that over the coming months, those employers in the sector who might not have used the furlough scheme, particularly for sort of teaching staff, might get requests from staff to be furloughed. And then just covering some of the other issues that we foresee coming up, there's been a lot in the press around redundancies and restructuring. Unions are very challenging of that because there's an alternative at the moment, and that is furlough. That's not to say that you can't go ahead and do it, but you'll need to be able to respond to those challenges from the unions. We also are beginning to see much more around long COVID. I'm sure you have too in the press, and that's going to be a real issue for managers, human resource professionals, thinking about that, because if people have had COVID and they are continuing to suffer ongoing conditions as a result of it, then it might be that these people have disabilities, and that will have to be managed in the workplace, and you'll have to think about adjustments for them. And then the last thing that I'm just going to touch on before I hand over to Lynn is thinking about contractual requirements. It might well be the case that in order for you to manage the transmission of the virus in the workplace, you are going to have to think very carefully about the numbers of students and teaching staff, other kinds of staff that you have on your campuses. And that might mean that you want people to continue doing some sort of hybrid arrangement for a while. If that's the case, you're going to have to think about whether you need to change their contracts. And another issue that is coming up increasingly, and indeed one of my colleagues has in fact written a blog about this, another blog to plug, are about whether you can start to impose requirements that people actually undergo workplace testing, and thinking about vaccination strategies as people start to be vaccinated and return to work. Can you impose requirements on staff to actually have a vaccine as a condition of employment? So quite a range of employment issues. I'm sure many of you have grappled with them and are already learning some lessons. And with that, I'm going to hand over to Lynn.
Thanks very much, Lynn. Good morning, everyone. So I'm now going to consider health and safety implications As many of you will be aware, the overarching health and safety duty incumbent upon an employer has actually not changed during the pandemic. It remains to ensure, so far as is reasonably practicable, the health, safety and welfare of employees whilst they're at work, as well as those non-employees that are physically interacting with an organisation, so your pupils, your students, contractors and members of the public. What has changed, of course, is the way in which education is being provided as a result of the pandemic. And so when you're considering your health, safety and welfare obligations, organisations should be taking account of the COVID-19 legal framework and the government guidance that was previously mentioned by Neil. So the pandemic and the government advice has required more lateral thinking as to health and safety arrangements that organisations have in place. And it's also heightened everyone's awareness of general health and safety. So turning now to look at the duty to risk assess, which is central to health and safety, there's no doubt that COVID has introduced new issues and new risks that have to be considered and managed. And many of the pre-COVID risk assessments and policies that were in place effectively were made automatically rendered defunct. So at the start of the first lockdown, we worked with many clients on their COVID risk assessments. Now, as the knowledge and practice of operating during this pandemic's evolved, COVID risk assessments are something that we're probably all very familiar with. However, as the goalposts are moving and guidance is being updated, it's amazing how quickly your risk assessment might become outdated or at least not be as up to date as might be expected. So I'm going to take a quick look at some of the things you might want to be thinking about just now. However, my key takeaway really is to ensure that that risk assessment is continually reviewed and a paper trail is kept of that process. The situation is fluid and risk assessments need to flex and be revised as new government guidance emerges. So ongoing review really is necessary to ensure that your risks are being appropriately managed. So as you may know, the current stay-at-home regulations place a duty on employers to take all reasonable steps to minimise the spread of coronavirus. And that includes supporting staff to work from home for roles that can be undertaken remotely. However, as Neil's mentioned, the guidance does permit that certain people can be on campus. So organisations need to be planning for the minimum number of people needed on campus to operate safely and effectively. And you might want to consider committing that to writing. In the event that you are faced by an inspection by the Health and Safety Executive, an HSE inspector, it will simplify matters if you can produce a written document detailing why your minimum number is that number. Remember though, if you are going to commit a minimum number to writing, you could be held account to that number if it's above or below that on any given day. Organisations will also be needing to consider how the campus is being accessed. Health and safety duties for employers have been extended by government guidance and HSE guidance. Pre-COVID, an employer's duty started at the doors of the workplace, but that's now been extended to include your employees' commute to work. Where possible, people should be avoiding public transport, but organisations need to be aware about how their employees will commute so that that can inform the assessment of the transmission risks and also guide their thinking on what measures need to be in place on arrival at campus, such as hand washing or sanitising facilities at the doors. I imagine you've all already been through the steps to ensure that physical distancing on campus and one-way traffic routes and socially distanced workspaces are all in place, so I'm not going to cover that here. What I would highlight though is the overriding duty on an employer in relation to COVID is to minimise or eliminate the risk of transmission insofar as is reasonably practicable. And that is, as many of you I'm sure will be familiar, a very wide-ranging and extensive duty. And it means that all aspects of the campus do need to be considered. So when you're assessing things like touch points on campus, you need to be considering where are the touch points that could increase the risk of transmission. The communal kitchen, door handles, stationery cupboard, lift buttons, these are all items that have been raised with us by clients as areas of concern. And each organisation's setup is going to be different. but it's best practice for all organisations to record in writing which touch point hotspots have been considered and to list the control measures in operation. Effectively, all work undertaken on campus needs to be reassessed to take account of your reduced numbers. Can the work still be done safely if there are fewer people there to undertake it? And what happens in the event of an accident? Is there someone with first aid training in your minimum numbers that are on campus? Has anyone in the group undertaken incident response training? Are they fire marshals? Do they know who to contact in the event of an emergency? And do you maybe need to consider producing additional information sheets to provide these to key supervisors or team members? These are all things to think about. And as Lynn just mentioned, once you've done your risk assessment process, you do have a legal obligation to consult your workforce on health and safety arrangements. And those who have a unionised workforce will do that through their trade union reps. And it's actually something we are seeing quite a lot of activity on, with trade unions really pushing employers to ensure that the arrangements are satisfactory for a return to work. So that advice really has focused on those returning to campus, but organisations should be carrying out similar exercises for risk assessments for home working. Lynn's touched upon that, and also for visitors to campus, such as contractors for cleaning and maintenance. So if I move on to consider the consequences of breach, hopefully it won't be news to anyone that failing to comply with your health and safety duties has very serious consequences. The HSE continues to exercise its regulatory function during the pandemic, ensuring ongoing compliance with health and safety, and also taking action against employers who aren't appropriately responding to COVID. And we know that the HSE carried out spot checks on schools towards the end of last year to ensure that they were COVID secure. But breaches of health and safety law can result in both criminal and civil liability, and criminal action can be taken against both organisations and individuals. And in the civil sphere, there are numerous types of damages claims that might arise, from infection with people contracting the virus on campus to new risks created by COVID or home working. And we have actually started to see claims from employees alleging to have contracted COVID at work, and we're assisting clients with those. And as Neil mentioned, there's also the reputational damage and loss of public faith in organisations who are not seen to be complying with their duties in this difficult time. And so turning briefly to consider insurance cover, the first type of cover that I was going to mention are policies that many people will be familiar with, which are employers' liability and public liability. And it's worth reviewing those policies just to ensure that the appropriate cover is in place in case your organisation is faced with the types of injury claims I've just mentioned. The other type of insurance cover to mention is business interruption cover, and that provides cover for losses connected to a business being prevented from trading. Whether such policies cover losses as a result of COVID has been the subject of much debate, and the Supreme Court recently issued a judgment, actually, the Financial Conduct Authority against Arch Insurance, and the citation for that's on the next slide. In discussing the implications of that decision is really a session in itself. But in short, policyholders who had their BI claims refused on the basis of policy wording not providing cover for COVID-19, and the case was brought by the FCA to provide clarity in terms of the correct legal interpretation of many BI clauses. And the court's decision is largely in favour of policyholders receiving payouts on their BI insurance policies. Each claim will, of course, turn on its own facts and the specific policy wording. But what I would say is, as a result of this decision, it is probably worth checking if your organisation has a policy, and if so, considering whether a claim should be intimated, or if it's already been intimated, following up on this in light of the judgment, even if the BI claim was previously refused. And finally, the last thing I was going to say in terms of insurance is, for all claims, in order to maintain your possibility of cover, it's crucial that organisations adhere to all policy terms. And that includes any specific duty to notify or warranties that have been given at the policy inception. So it is important you're aware of them. So that was a sort of brief whistle-stop tour through health and safety insurance. I'm now going to pass you over to Joyce, who's going to discuss the education provider and the client's perspective.
Thank Thank you, Lynn. Well, as Neil said at the outset, I'm in a slightly unusual position, I suppose, of being both legal advisor and the recipient of legal advice as a litigation partner at Brodie's, and then wearing my hat as chair of the governors at George Heriot's School. And I've found that, I have to say, is a very useful reminder that for a client, simply following the black letter law advice is not always palatable, and how the advice, for example, about the legal right to recover fees from parents during a pandemic is implemented must take into account how actions will be perceived by the head of the school, the bursar, who is to deal direct with the parents, and by the governing body, who will be, of course, keen to keep pupils in their school and keen to preserve the bond with parents in these times. So there are several stakeholders to be considered. Students, whether at school or at college or university, you can be sure they will have a view, and that will be expressed sometimes quite strongly. Parents, largely applicable to school pupils, where in the independent sector they are meeting the fees, but also in universities where they will often be paying fees and accommodation costs. Staff, who are so important, of course, to have on side in any organisation, but in the education sector are absolutely front and centre to what's being delivered, and they really should be kept on side as far as possible. And finally, governors or members of university court, who have the legal responsibility of safeguarding the school, the university's finances, but will also be very concerned about the smooth running of the organisation, supporting their senior teams, keeping the students and parents on side, and of course the reputation of the organisation. So first of all then, looking at the students, I'll deal with this really very briefly because I'm not an expert in how to provide education. For older pupils and students, there is little doubt that their biggest concern will be will they get the qualifications they need to move on either to college or university next, or if they're already at university, the degree that will enable them to take the next step in their careers. For all students, there'll be worries about the effect of not being with their friends and teachers and the experience they would normally expect. Who'd have thought a year ago that children would be complaining about not being at school? But I think the theme of what I would say today generally is that communication is key with pupils and students alike. And while that would really be a subject for an entirely separate webinar, it's absolutely clear from the anecdotal evidence that we've been hearing that, you know, understanding what the pupils are looking for, what works best for them, is very important to communicate with them. Going on then to parents, in many ways, the most challenging of stakeholders. The contract, of course, is between the school and the parents. So the challenge for the school or university is to demonstrate that the school is using its financial resources, primarily their fees, to best effect, to ensure that they feel they're getting value for money despite home learning, and that the core contractual commitments are met. No doubt all organisations have been looking quite hard at the agreements that they have with parents already to see what they've actually offered in exchange for the fees. And I know that many organisations have made tweaks, particularly for new entrants into schools, to ensure that they cover home learning type of experience that we're all having to offer. Many organisations will, of course, have sought to control costs in the past year, and so while allowing essential maintenance and improvements to carry on, upgrades, major spending plans are tending to be put on hold to see how things go. Many independent sector schools I know have cut fees or given rebates for example, last summer term, either across the board or for particular year groups. Others have chosen to go down the route of assisting those parents whose finances have been most directly affected by COVID through, for example, emergency bursaries or fee deferment. And these decisions will very much depend on the relationship between the organisation and the parents. The use of the furlough scheme, where employees simply cannot do their job from home, has been used by many organisations. But again, of course, it needs an explanation. Government cash is being received, yet schools are still charging parents full fees. So what is being spent, what the money is being spent on, needs to be communicated. Similarly, an explanation of what the savings through cost cutting is being used for is needed. So the organisation is not providing all services or incurring all the usual costs. For example, buses to sporting activities, subsidies to wraparound care, subsidies to refectory. So why are these savings not being passed on to the parents? And again, communication is key for parents. Explaining the policy decided on, whether it be homeschooling arrangements, fees, cost cutting, additional income received from furlough. Organisations have found ways to communicate and invite communication from parents and other stakeholders. And it's important, we've discovered certainly, to ensure that the correct routes for communication are provided to parents. So the right email addresses to deal with educational or pastoral issues, the right email addresses to deal with financial issues. Using parent portals, for example, having weekly Q&A sessions for parents, or the usual means of meetings between governors, senior staff, parent association representatives, etc. But again, communication is key if the organisation is going to thrive. Moving on then to staff, I'm not going to say terribly much about staff because both Lynn's have dealt with the health and safety aspect and the human resources employment law aspects. But I think it's very important, again, as I said at the beginning, to keep staff on side. Teaching and pastoral support staff have been working incredibly hard, putting themselves at risk to some extent, and that needs to be recognised by the school, the college, university through the extra safety measures which have been talked about, and of course ensuring that contractual commitments are met. But it's also important, I think, to demonstrate that goodwill is not taken for granted, and balancing reward and recognition whilst taking account of possible perceptions of other stakeholders, parents who are paying fees but spending hours homeschooling their own children, and students who are not being offered the usual university or college experience. Some staff who've been furloughed and others who've not been furloughed, all of this needs to be handled particularly sensitively. And again, communication with staff, very important, not just the black letter law, although following that advice is obviously very important, but communicating and making staff feel that they are valued and that things will go back to normal eventually. Finally, then, turning to governing bodies, I am very new in my role as Chair of Governors at Heriot's. Great timing, I know, in 2020. So I don't know how things have been done in the past always, but I have come to appreciate that in the usual well-ordered budgeting planning processes for the year are likely to have been thrown into disarray in most organisations. And there will be some anxiety on the part of governing bodies. While they're supportive of changes to timetables for information being received, etc., there is still a need to demonstrate that business as usual is carrying on, particularly on finances. So the bursar and the finance team are incredibly busy, of course, with firefighting on day-to-day issues, dealing with furlough, dealing with insurance, dealing with managing the way that the school operates. But budgets which have been agreed for increasing fees and for capital spending may no longer be able to be kept to. So there needs to be flexibility from the governing body, but also reassurance given to the governing body. And again, communication is key. Sometimes it's just headlines that the governing bodies need, but they do need to be kept informed. As I said at the outset, they are legally responsible for the finances of the organisation. So, for example, that the fee income has come down, but not by more than is budgeted for at the start of the lockdown, very important to hear. That the school roll is still full and that there are still waiting lists for next year in place. Even if it has to be assumed that that won't necessarily be the case in years ahead, because not all families will be able to continue to send the children to an independent school, for example, because their family finances have been hit. And again, importantly, that cuts to spending are matched to cuts in income in the short term, and that there are contingencies in place if things change. So just wrapping up then, for schools, colleges, universities, As for all businesses, it is a balancing act, and taking account of all of the stakeholders, communicating more effectively than ever before that the organisation is still functioning and is doing the right thing until eventually it can get back to normal, perhaps with relationships even stronger than before if the crisis is well handled. So really what I'm trying to say is that the black letter law, of course, is important, but communication and the soft skills and all the things that schools and universities and colleges are good at doing, they need to have an increased focus during this pandemic. So handing back to Neil, I think, for some questions he has, I hope.
Yes, well, thank you very much, Joyce, and to both Lyns for their presentations there. I think we have stuck to what we said we would do, which was to deliver 4 short 10-minute presentations and allow time for questions. The first question that we have is about the risks for universities if students return to term time accommodation, notwithstanding the government guidance. So what we obviously know happened before Christmas is a lot of students went home, and the question is what happens if they go back. Now, I mean, as I said at the outset, one of the reasonable excuses for leaving your home is to attend education, including school, college, or university education, provided, of course, that it's essential for you to be there. So as a student, you would have to be doing one of the courses, which meant that you needed to be on campus, and that's likely to be restricted to most of the clinical or practical courses. The risk first lies with the student. If they have left and returned to their term time accommodation without a reasonable excuse, then they are committing an offence. Of course, that doesn't help you as a university, because you'll want to be thinking about, well, what do you do in that situation? And I'm going to say maybe a bit about student discipline, and I'll hand over to colleagues to come in with any other points they want to make. I mean, as I mentioned as well, you obviously need to have student discipline policies, and what the government guidance is saying is that a breach of the coronavirus rules and regulations is a student discipline offence. So you'll want to be seen at least to be dealing with the student under your disciplinary policy, alongside any action that the police may or may not take. And key to that is going to be, as Joyce has picked up on, communication. What have you said to students about returning home? Have you checked that it's absolutely consistent with what the guidance says? And are you clear about the expectations if students choose to ignore that guidance? And one of the things you might find particularly challenging is students saying things like they want to return home, they want to return rather to their term time accommodation to pick up books or to take part in their course, and you've just got to be alive to the risk and really, instruct your staff to, not to question too closely, but to at least understand, is there a real genuine need for the student to be back on campus or not, and to take steps accordingly. So I think that's all I wanted to say. I'll hand over to others if they've got anything to add. No.
Neil, perhaps I could just say that I think for universities and colleges and schools, there's really no difference between them and any other employer and organisation that is running any sort of business, is that they have to be able to be sensitive in asking the right questions. I know that, for example, at Brodie's, if we want to go into the office to do something or to pick up books or whatever, we have to fill in an online form and get permission from someone. And I think if that was communicated even to students, that if they want to do that, there's a way of doing it, but you have to have a justification and you have to have permission to do it. I think that would be one way, potentially. Yeah.
Thanks, Joyce. No, that's a really good point. The next question we have is quite an interesting one. I think it falls to me to initially give an answer, but I'm very conscious we're joined by colleagues from Scottish Government who may be able to help with the answer to this in the chat function. So we're being asked whether we've got any views on the requirements in the School Consultation Scotland Act 2010 to hold a public meeting for education statutory consultations during the pandemic. The person asking the questions explained that they have a number of consultations which they require to undertake, and they plan to hold those virtually, but they're aware there's an element of risk of legal challenge involved with the current wording of the legislation. So what the legislation requires at the moment, of course, is a public meeting. Now, as far as I'm aware, and colleagues on the call can correct me, there's no definition of public meeting, nor has it been changed in relation to any requirement under the coronavirus legislation. So it's in a slightly different place from regulation making powers in relation to local authority meetings or the meetings of creditors in a bankruptcy situation where specific provision is made. And answering the question, I'm first going to give a plug for our local government handy guide. There is an entire section in that on local authority meetings. And of course, local authorities have already and have for some time had the power to hold remote meetings. And that comes from the Local Government in Scotland Act. So particularly councils with a rural spread of wards or areas have already held meetings virtually, so we'll be able to do that. I suppose the question is slightly different. If an Act says have a public meeting and you hold a virtual one, are you in breach of the strict statutory rules? And my response to that would be that you go back to first principles and you say, well, what is the point of the consultation provision? Well, it must be that people have to take a meaningful role in the exercise and be able to share views and discuss the proposal that's being put forward. And if they can do that virtually, then my immediate reaction, and I may follow up to the question asker in writing, is that there wouldn't be necessarily a breach. And of course, any challenger would need to set out quite clearly how they had been disadvantaged by the holding of a virtual rather than a public meeting. And then of course, in holding a virtual meeting, and we talk about this in the local government handy guide, you have to be alive to all of your other legal duties. So thinking about things like your duties under the Equality Act, and that is something that might impact on the ability of a person to take meaningful part in a virtual meeting rather than a public one. Those are my immediate reactions to it. I'm not seeing anybody in the chat coming back to correct me, and I'm not sure if colleagues want to add anything on that particular question. No.
Nope.
No. Okay. Next question, and it comes from something that Lynn Marr, you said. I think you closed your section by talking about vaccination programs, and I suppose the question we have for you is, can you make compulsory vaccination a condition of employment?
You can try. I think it might be quite difficult. I don't know if this question's come from, there was quite a lot of press last week about Pimlico plumbers saying that they're going to force all their contractors or self-employed people or workers or whatever they're classified as to get the vaccine. I think it might be quite a tricky one. I mean, obviously our government hasn't legislated to say that people have to have the vaccine. It's a pretty intrusive thing to ask people to do if they really don't want it. So without their consent, how are you going to enforce it? So I think there are a lot of difficulties in terms of just having a mandatory policy, because what are you going to do if people refuse? Are you going to dismiss them? Because if you do, then the chances are you might end up with an unfair dismissal complaint. There are lots of issues around discrimination. So there are lots of reasons why people can't have vaccines. Might be something connected to age. I think some of the vaccines are not suitable for particular age groups. Pregnant women shouldn't have vaccines. There will be people that are just don't want the vaccine. They might have a philosophical belief about vaccines. And there has been a lot of press, although I think it's what you might categorise into being fake news, about whether vaccines have things like gelatin in them, and therefore whether certain religious people of particular religions might not want the vaccine, or vegans, for example. So there's potential for a whole raft of discrimination complaints as well if you force people or say that they've got to have the vaccine as a condition of their employment. I mean, that said, we know that there are some, I haven't had any, I don't think, in the education sector, but certainly some clients in care sectors where they've really strongly encouraged vaccines, and then they've told people they have to have the vaccine. But obviously slightly different scenario, and this might apply if you have staff who are going to be in very close contact with particular groups of vulnerable people, depending obviously on their area of expertise. Then you might be able to get closer to having a material or substantial reason, I guess, for asking them to have the vaccine. I think that will probably depend very much on the sort of individual circumstances. So I guess, in short, having a mandatory policy is probably not sensible, and you might have to do it by sort of trying to get people to do it voluntarily in the first instance, and then think about individual circumstances where you might want to make it a condition.
Great.
If I can just give a plug for Lynn's, or rather employment team's, excellent blog that came out last night on this very subject.
Julie, yeah, Julie has done a blog. It was Julie that also did the blog on employees that may be abroad, which is also a good read.
Great, fantastic. I did say we wanted to have about 10 minutes for questions. We do have this in for an hour, but I'll maybe just ask one more question before we close. And I think it's one for Joyce. Joyce, you obviously talked about students putting their views across quite forcefully in a range of sectors. And obviously you touched upon the contractual issues that might arise. Are you anticipating that there might be a rise in breach of contract claims or complaints? And if so, have you got any tips as to how you would manage those?
Well, I suspect that those who are listening to this may already have received some at least disgruntled complaints. Whether they'll turn into actual actions being raised is another issue. Certainly now that Scotland has group proceedings rules available, it's certainly something we've been talking about internally as to whether, for example, groups of students who feel disgruntled about what they've received for their fees for the year will join together. Will get some solicitor, and there are many of them out there who are willing to take on group proceedings for large numbers of pursuers, whether they'll get together and raise proceedings for breach of contract effectively. And again, it will very much depend on what's in the contract. Obviously between schools and parents there are specific contracts written down. Universities too will have certain minimum standards that they are obliged to provide, and if the students argue that they've not had those minimum standards, they may be seeking refunds or whatever. I've been reading about that in the press rather than having seen it from clients directly, but I certainly wouldn't be surprised if somebody had a go.
Thank you very much. I think that probably takes us to the end of today's session. So all that remains for me to do is to thank, obviously, my colleagues as speakers, and to thank you all for attending today. We will circulate a recording of the webinar for you to view or to share with colleagues. And if you've got any questions or any other topics you'd like us to cover, then please do get in touch direct. Thank you all again.